Here today for a final pretrial conference in this case ahead of a trial scheduled for June 20th and 21st. We are proceeding today partially in person and partially by video conference. First, let me have the attorneys place their appearances on the record, beginning with Ms. McClure.
E.B. McClure filling in for prosecutor of record Isaac Sneed.
Samaris Hennigan on behalf of Donald Lester.
All right, and Mr. Lester, I believe, is in the jail Zoom 2 device. Mr. Lester, are you there?
Yeah, I'm here.
All right, so I don't know what's going on with the camera. We can't see you. It looks to be shooting at the almost. I'm saying that we can't see you, Mr. Lester. So, Ms. Hennigan, where do we stand? Are we ready to proceed to trial on June 20th?
Thank you, Your Honor. I met with my client yesterday and did make the final offer to him with regard to plea agreements. My client has declined to accept the plea that was offered by prosecution. I also was informed by my client that he has filed a few motions. I guess you would say pro se. I have not seen those motions myself, but he says he mailed them to the court. He does have many objections to the proceedings. That being said, the next step that would be appropriate with regard to our legal procedures would be to go forward with trial. I am prepared to do that, though I do believe that my client will object to that, Your Honor. So I do want to make sure that I represent his wishes as well, while I still inform the court of whether or not I'm ready to proceed. So I will be ready to proceed for trial next week. That being said, my client does not want to go to trial as he feels that the court doesn't have jurisdiction over him on this matter.
All right, buckle up, because this isn't just another sovereign citizen court appearance. This is the return of a man who already proved, on the record, that silence is his greatest enemy. The last time we saw him, he managed to talk himself into 93 days in jail for contempt ***, not because of evidence, not because of a jury, but because he simply could not stop arguing with the judge. Today's hearing is his final pre-trial conference, which is basically the courtroom equivalent of a last off-ramp before everything gets worse. And here's the twist, the court is actually offering him something rare in sovereign citizen cases, a reasonable plea deal and a path out of jail. Here's the real question, can someone who believes the court has no jurisdiction, the laws don't apply to him, and words have magical legal powers,
upset? I would add, just for the record, for his for appellate purposes for him, that he was upset that I agreed to a trial schedule at a past hearing, and I did try to explain to him that that's just a procedure, that the court is on timeframes according to statute, and that at some point we do have to set a trial schedule, even though it was my intent to continue to try to negotiate this case for him along the way.
All right, to the extent that there's any objection based on court's jurisdiction,
I can't hear you. Can you speak up, please?
To the extent that there's any objection to proceeding to trial based on the court's jurisdiction, I would deny that, as the court does have jurisdiction over this case. It is a felony case involving an alleged felony which is alleged to have occurred within Lenawee County, state of Michigan. This is the circuit court for the Lenawee County, state of Michigan, and therefore jurisdiction is appropriate. Ms. McClure, is there anything we need to address from the people's side?
The people have not received any motions that have been referenced, but as far as I know, we are prepared to proceed to trial next week as well.
Right.
All right, so do we have proposed jury instructions and voir dire questions yet?
We do not, and I spoke with Mr. Sneed yesterday, but I'm certain that we can agree upon those within the next day or so.
I see some in our file, so maybe he's drafted them and just not.
Yes. He was working on them.
Okay, so I'll need those by the end of the week so that we have an adequate amount of time to get prepared
Right.
for trial.
I would also like to intervene here real quick, but that being said, the motion is just not for the jurisdiction, it's also for personal jurisdiction and subject matter jurisdiction. I had the right to a resisting unlawful arrest, and it's not being addressed. The Supreme Court ruling on that, I just read that not too long ago, and they arrested me for an old traffic ticket, is where it started at. They're trying to dodge the point of where they harassed me for 3 days before they arrested. And as far as this possession situation go, I was informed yesterday by my attorney, who I haven't talked to since March, that I was looking at 14 years. Under your court, Michigan rules that after 10 years, under a lower
Right away, notice how routine and calm this courtroom is. This is not a hostile environment. No one's rushing him, no one's yelling, the judge is doing exactly what judges do, confirming appearances, making sure everyone's present, and keeping the process clean and orderly. But here's the key detail most people miss: this is already a felony case, and the defendant is appearing from jail. That alone tells you things have gone well beyond a simple traffic dispute, no matter how often he'll try to drag it back there. Also, pay attention to the attorney. Defense counsel is calm, professional, and clearly trying to manage expectations, which is not easy when your client believes court jurisdiction disappears if you say the right combination of words. This is where the tension starts building, because
so there should be somewhere in y'all file that y'all should have it.
Your Honor, I did.
And personal. And like I said, I haven't talked to this woman since March. She told me that I was going to be released out for bond, and I haven't heard anything from her since then. I wrote her a letter. The first time I seen this woman in about 2 or 3 months, his first time was yesterday. And she doesn't represent the said name anyway. I've talked to her about that situation too. Somebody's not being truthful here. And I've been sitting here almost 10 months without a bond or even so much as calling my witnesses. She's never asked me anything. So my due process is being violated. Also, I'm sitting in here on an unsigned warrant. Unsigned. A probable cause warrant. They trying to make it look like they arrested me for those charges, and it's not what it was for. That's not what it was for. I was arrested for driving on a suspended license from back in 2016. That case got dismissed.
Your Honor, I did inform him
He's not
yesterday.
addressing none of those issues, Your Honor. Period.
Mr. Lester, I need you to stop interrupting people, okay? What is it that you wanted to say?
I did inform him yesterday that the charges he was facing could, that it's up to 14 years because there's consecutive sentencing available on those charges. He has a felony that is up to 10 years and then 2 R&Os which can be sentenced consecutively if that were requested and or if the court were to do it. And I informed him of that at the time that I was telling him about.
And here we go, the plea deal gets declined. This is a huge asterisk moment, and the defendant may not even realize how big it is. Plea offers don't exist to be friendly gestures, they exist to resolve cases efficiently. When one is offered at this stage, it usually means the prosecution feels confident, but is still willing to cut losses. Now notice how the attorney carefully explains that trial scheduling doesn't mean abandoning negotiations. That's standard procedure. Courts operate on timelines, not feelings or personal belief systems. But sovereign citizens often hear that as betrayal, because they think agreeing to a schedule somehow grants jurisdiction that IT doesn't.
Notice, and he asked me about that yesterday, and I reiterated again yesterday that is not why. That is not why he's facing that amount of time. It was simply me telling him worst case scenario in this matter.
All right, so to the extent that personal jurisdiction issue has been raised in addition to subject matter jurisdiction, and again, deny any request on those bases because the court, again, has personal jurisdiction over Mr. Lester, who is a human being located in Lenawee County, Michigan, and alleged to have commit a felony crime in Lenawee County, Michigan.
How did I commit a violent crime?
With respect to the argument that Mr. Lester made regarding the right to resist an unlawful arrest, that's why the court is having a trial. One of the elements that the prosecutor needs to prove in a resisting and obstructing case is that the officers were on duty, acting lawfully, and made a lawful arrest that Mr. Lester resisted. So that's the purpose of the trial. With respect to any issue about expunged convictions, we're not even to that point yet. The habitual offender issue comes into play only after a conviction has entered, and then the court has to determine whether the convictions listed in the habitual offender notice in fact happen and can appropriately be used under the statute for the sentencing enhancements that have been notified in the information. And so
okay, so
whenever
you get done, I'd like to address the issue too, please.
All right, I'm going to mute Mr. Lester because I can't have people talking over me while I'm trying to create a record. All right, so then we are ready to proceed to trial on June 20th. Again, I'd like to have the voir dire questions and jury instructions ready or to the court by the end of the week so that we can have those ready to go.
Thank you, Your Honor.
Yeah. Before we go,
Ms. McClure, can I just understand from you what that final offer you made on this case, or what the final offer the prosecution made on this case was?
Yes, it would be.
Ms. McClure, I actually have a copy that I could pass to the court too, if that's okay with you.
Yeah, I mean, we'll just take a second. It's an.
This is one of the most important moments in the entire hearing, and it happens calmly, without drama. The judge doesn't argue. He doesn't debate philosophy. He simply states facts: felony charge, location of offense, proper court. Jurisdiction established. Full stop. This is what sovereign citizen arguments always crash into: reality. Courts don't need permission. They don't need contracts. They don't need the defendant's agreement. Jurisdiction is a matter of law, not consent, and noted
Lester were willing to plead guilty to possession of methamphetamine in a park. That's a 2-year maximum possible penalty, but the prosecution has also agreed to credit for time served and or fines and costs, and a personal recognizance bond release until the date of the sentencing. Is that all accurate, Ms. McClure?
What is that? That
Yes.
is crazy.
Yes,
All
that's
right.
accurate, Your Honor.
And Mr. Lester is not interested in agreeing to that plea. Is that correct?
It's my understanding, but it seems that he would like to say something about it, Your Honor, so I prefer that he answer that question himself.
Yeah, I would like to say something because of the fact that you keep trying to let me out on a PR bond and you want me to come back to court for sentencing, but you won't let me out to try to get my witnesses and gather the evidence that I need to be able to present it at trial. I haven't even went over this one. I haven't even went over any kind of defense with this woman. I am being prosecuted and persecuted by her and a prosecutor. And it's obvious.
Mr. Lester.
You keep trying to cut me off.
Well, that's because you won't let me create the record and do my job. So I'm
trying to do my job. You're not the one sitting in jail, sir.
Your Honor, would you please mute my client? I don't want him to.
Record should reflect that. The record should reflect that Mr. Lester had. I'm sorry. So, Mr. Lester, the question I'm asking and that I need an answer to is you've heard the offer that I've.
Now watch carefully, because this is where self-control becomes the deciding factor. The judge is discussing logistics, jury instructions, timelines, preparation. This is procedural, boring, and incredibly important. For most defendants, this is the moment you stay quiet and let your attorney work. But for sovereign citizens, silence feels like surrender, and that's when they jump in, and every interruption does two things: it weakens the defense and it reinforces the judge's earlier contempt finding. The court already knows this defendant struggles to follow basic court